See, this is only a 10 days program. Point number 1. So, we will rush. Your attitude must be like this. You should catch us, you should use us. Point number 3, we are under a presumption that you have studied something under law. And perhaps that interest motivated you come over here. So therefore, my submission to all of you, please try to read and come. Point number 1. Why I gave you this leaflet is so that you can understand what we are going to discuss today. We are touching very basics of law. So unless your understanding of civil law and conceptual clarity of property is clear, you cannot get through this exam. Nearly more than 3 years, isn't it? So everybody might have studied well. It doesn't, they have studied well. It is not clear whether they understood or not. And we are arrogant to tell that nobody can understand. Because it requires a different attitude, culture and thinking to understand it. It's not mere reading one book by purchasing it in a market. Even whatever book which we give also, it only guides you. Ultimately it is a teacher who could put you inside, who could help you to understand in a right manner. So their pulsar is there basically to act as a bridge between your mind and the textbook. In fact, I was asked by one High Court judge sometime back when I was teaching in Nalsar. He asked me, Anil, for Nalsar students he is supposed to teach a lecture. He asked me, Anil, how should I teach? I told him, sir, don't teach from the book. He asked me, should I teach practicality? If you teach practicality, at the end they will say that he taught what is not there in the book. How we should write the exam. So, book lo unnadi chepte book lo unnade cheptunnadu ga maakenduki teacher antaru. Book lo ledeni chepte book lo ledeni cheppadu me exam ralem antaru. Isn't it? So at the end what is happening? It's a suffering to a teacher. So మీ చేతిలో ఉన్న పుస్తకాలు మీకే అర్థం కానట్టుగా కొత్తగా వింతగా చెప్పడానికి టీచర్. So we are here to make you understand what is there in that white paper, black letters law in a new dimension. That's why we are here. Am I clear, friends? That is our fundamental goal. I am telling you these 10 days very stimulating affair, very intellectually enlightening affair. So my submission to all of you, be attentive, be focused. And let me remind you, we don't teach you the entire subject. It is not necessary. What is required is the areas where there will be a serious concentration, a much emphasis and focus. Though apart from that, while we are teaching, don't interrupt us with doubts. At the end, definitely you can ask any number of doubts. There is no problem. We invite doubts, we clear doubts. But one thing keep in your mind, your doubt shall not indicate your lack of basics. Okay? So be conscious of that fact also. Am I clear, friends? So that's one thing. Whether 10 days is enough. Because it's a 5 years course, isn't it? It's basically refreshing your memory. It means refreshing means what? What is refreshing? It is already there in your mind. We are clicking a refreshing button so that it will be refreshed. So we are only refreshing what is already there in your mind. It's not that we are teaching something new. Perhaps the methodology of teaching might be new, but we are only teaching what you already know, so that your level of understanding, your memory levels will get geometrically multiplied or enhanced. That is the fundamental purpose. So far as clearing prelims, we could tell you definitely more than 80% questions will be from the whatever we discussed, what is there in your reading material which will be given. Despite the reading material, my submission to all of you is read interpretation class from all Beracts. There shall be at least 20 to 30 questions from interpretation class. You are supposed to be very thorough with definition class. Comment clear, friends? Read it. And another important submission to all of you, you are supposed to carry Beract. Very important. Carry Beract, hold that flags and marker so that you will identify. And let me also remind you, you carry Beract as if it is your friend. You should maintain a proper relationship. You must have a proper bondage with your book. Unless that happens, I am telling you, you will never feel like reading. Isn't it? Many people might have felt a sense of attachment with a particular book. Isn't it? ఉందా లేదా ఫీలింగ్? ఆ బుక్ లోనే చదువుతాను అంటాడు. ఏముండదు, అన్ని బుక్కులు లాగా ఆ బుక్ ఉంటుంది, బట్ స్టిల్ ఆ అటాచ్మెంట్ ఉంటుంది. బికాస్ యూ షుడ్ బిల్డ్ దట్ అటాచ్మెంట్ విత్ బుక్, బికాస్ ఇట్ ఇన్సైట్స్ యూ టు రీడ్ ఇట్, బికాస్ ఆఫ్టర్ ఆల్ బుక్ ఈజ్ ఎ ఫ్రెండ్. Isn't it? So purchase some flags, 5 rupees, 10 rupees flags and marker, identify important areas which we discuss in the class. So ultimately the questions that will be asked in the exam, they are directly from the Beract. Isn't it? You must have seen. They are directly from the Beract. So you shall read Beract. This is one important thing. Number 2. This is only objective examination. You should know the important words that important words. That important words you can appreciate only if you read Beract. XYZ, ABCD, Anil Kiran Kumar ila rasna books ni nammadu. You just don't rely those books. You just use it for your guidance, nothing else. Read always Beract. And another important thing, there is no question of asking citations, because our mind is trained to write one stupid citation and get marks. Let me remind you, even in the district judge exam they are not asking citation. Civil judge exam there is no question of citation. Even if there is a citation, you just leave it. I am telling you. Perhaps it might be a very landmark case that will be asked. Generally, as a matter of rule, no prudent man would ask you a citation based question. Read Beract, nothing else, because Beract's life is more than 150 years. Your citation is perhaps maybe 1 year, 2 years or 10 years. Okay, Beract is final authority. You are supposed to read Beract. As I told you, it's only objective examination. Focus on catching the important words. For example, voluntarily is there under IPC. The word they have used is knowingly or intentionally. You try to catch those words. So be attentive, focus towards certain important areas, certain important definition, certain important legal job. Okay. For example, there is a definition called injury. Isn't it? Have you heard this definition? Injury means any harm which is caused illegally, mind, body, reputation, property. Isn't it? So when you read it, don't by heart it. Try to catch the essence of the definition. Okay, friends. So that is one important thing which I want to put it in your mind. And let me remind you, mugging up is also very equally important effort. Do you know why? Exam does not require a creative human being. They want a ready-made person. They want a ready-made person who could deliver goods at a faster rate. అక్కడికి వెళ్ళి మీరు ఏదో some Supreme Court లాగా థింక్ చేయడానికి you should answer at a rapid speed. ఆ స్పీడ్ రావాలంటే మగప్ చేయాలి. And mugging up is not an inferior effort. Let me tell you, it's a most superior effort. You can be creative only if you mug up. అవునా కదా? What is creativity fundamentally? Creativity is connecting two things. Isn't it? XY, there is 1, there is 2. 1 plus 2 is equal to 3. ఈ కలపడం ఎప్పుడు జరుగుతుంది? నీకు 1 ఉంది 2 ఉందని మైండ్ లో ఫిక్స్ అయితే, అది ఎంత ఫిక్స్ అవ్వాలి? సబ్ కాన్షియస్ లో రూట్ అయ్యే విధంగా ఫిక్స్ కావాలి. ఆ ఫిక్స్ అయితేనే క్రియేటివిటీ వస్తుంది. నీకు ఈ మెటీరియల్ లేకుండా క్రియేటివిటీ ఎట్లా వస్తుంది? రాదు. సో అన్లెస్ యూ మగప్ లైక్ ఎనీథింగ్, యూ కెనాట్ బి క్రియేటివ్. పర్హాప్స్ మగప్ చేసినా క్రియేటివిటీ రాకపోవచ్చు, అది మనం ఏం చేయలేం. బట్ ఫస్ట్ ఈ టెస్ట్ పాస్ అయితేనే సెకండ్ టెస్ట్కి వెళ్తారు. ఓకే, సో యూ హ్యావ్ టు మగప్. దట్ ఈస్ యువర్ ప్రాబ్లమ్. డోంట్ సే దట్ సార్ నాకు అలా మైండ్ యాక్సెప్ట్ చేయదు, అలా కుదరదు, ఇబ్బంది, నీ కర్మ, నేనేం చేయలేదు. ఓకే, యూ హ్యావ్ టు మగప్. That's one. Coming to today's class, today we will give you a very broad understanding of certain important concepts relating to law. In national law schools like Nalsar, NLS, Bangalore, in such schools there is so much of emphasis on jurisprudence. So so much of emphasis and they teach like anything, jurisprudence. Whereas ordinary law colleges, there is no, I don't know what is their level of emphasis, but either in LLB or LLM, there is a focus on jurisprudence. Let me remind you, jurisprudence is mother of all laws. Unless your understanding of jurisprudence subject is amazing, fantastic, spellbound, you cannot appreciate any other law. Am I clear, friends? So today we will try to put in your mind some important basic concepts related to it. Because if you appreciate this class, I am telling you the remaining classes are like a cakewalk for you. So point number one, if you read jurisprudence, the first chapters, they contain different schools, isn't it? Analytical school, positive school, philosophical school, sociological school, realistic school. Many schools are there. What they try to do is, from their perspective, they are trying to define what is law. Isn't it? From their each perspective, they are defining law. At the end, nobody gives a concrete definition. From that analogy, what you should understand is, జడ్జి అంటే కూడా అందరి సైడ్లు తెలుసుకోవాలి, కానీ అలాగే జీవితంలో అన్ని షేడ్స్ మీద ఒక ఒపీనియన్ ఫామ్ కావాలి, అన్ని షేడ్స్ని అర్థం చేసుకోవాలి, కానీ ఒక యూనిక్ షేడ్ తనంత తాను ఫామ్ చేసుకోవాలి. అర్థమవుతుందా? వెదర్ యువర్ సివిల్ సర్వీసెస్, వెదర్ యువర్ జ్యుడిషియల్ సర్వీసెస్, అల్టిమేట్లీ దే ఆర్ డీలింగ్ విత్ లైఫ్స్ ఆఫ్ హ్యూమన్ బీయింగ్స్, ఇజంట్ ఇట్? సమాజంలో రకరకాల మనుషులు ఉంటారు. వాళ్ళ యొక్క పరిస్థితుల్ని, వాళ్ళ ప్రాబ్లమ్స్ని ఎప్పుడు అప్రిషియేట్ చేయగలం? వాళ్ళ లైఫ్స్ మీద నాలెడ్జ్ ఉంటుంది, ఇజంట్ ఇట్? సిమిలర్లీ యాజ్ ఎ జడ్జ్, యూ హ్యావ్ టు అండర్స్టాండ్ ఎవ్రీ కాన్సెప్ట్ అండ్ డెవలప్ యువర్ ఓన్ కాన్సెప్ట్. మనం జనరల్గా ఏం చేస్తామంటే ఎప్పుడో సరిగ్గా చెప్పడానికి వదిలేస్తాం. డోంట్ ట్రై టు క్యాచ్ ఫర్ వన్ స్పెసిఫిక్ డెఫినేషన్ వెన్ ఇట్ కమ్స్ టు జూరిస్ప్రుడెన్స్. అందరిది వినండి, మీతో ఒకటి డెవలప్ చేసుకోండి. దట్ ఈస్ ద రీజన్ ఫర్ గివింగ్ వేరియస్ స్కూల్స్ అండర్ జూరిస్ప్రుడెన్స్. Similarly, we have many schools. Even I don't bother you with all those schools. The point to be taken is, the summary of all those schools is like this. Law contains the following. Number one, right, remedy. Number three, redressal. Chandra, right, remedy, redressal. Salmon definition చదివారు ఎవరైనా? Salmon అనే పదం విన్నారు ఎప్పుడైనా? Have you heard of him? Salmon says law is a what law is? Right recognized by state, enforced through machinery called administration of justice అని ఒక డెఫినేషన్ ఇస్తారు. So what he says, law అంటే first you must have a right అంటున్నాడు, isn't it? లాని కోర్టులో అడ్మినిస్ట్రేట్ చేయడానికి ఒక జస్టిస్ సిస్టమ్ ఉంటుంది అన్నమాట. త్రూ ఒక రెమెడీ ద్వారా ఇస్తారు. లా ఈజ్ ఏ రికగ్నైజ్డ్ బెనిఫిట్ బై స్టేట్ అండ్ ఇన్ ద ఈవెంట్ ఆఫ్ ఇట్స్ వైలేషన్ అడ్మినిస్ట్రేట్ త్రూ ఏ కోర్ట్ బై అవార్డింగ్ ఏ రెమెడీ. సో మనకి అన్నిటికంటే ఇంపార్టెంట్, మీరు లా ఆఫ్ టాక్స్ చదివారా లేదా ఫ్రెండ్స్? First semester they will teach one important concept. Damnum sine injuria, injuria sine damnum. Let me remind you, this is the very basis of your entire legal system. If you want to step into the court, your legal right must have been violated, isn't it? It is not a violation of economic, political, social right. Your legal right shall be violated, isn't it? If you read the definition, that's what they are trying to tell you. So the point is, when you interact with your client, you should know to file a case, what is the right of that fellow is about to be violated or violated. This is the fundamental premise, friends, isn't it? Do you know what is decree? There is a definition called decree, isn't it? Under definition decree, what it says, decree is a formal expression of an adjudication, isn't it? Which conclusively determines dash. What it decides, isn't it? So the basic thing which you should catch from these two definitions is, if you want to go to court, you must have a right. Unless you have a right, you cannot approach court. Your entire law is existence of certain rights, like what is constitution? Fundamental rights, isn't it? What is contract law? Contractual rights, isn't it? What is me and your relationship? It's a contractual, isn't it? I made a proposal, you accepted it, you have joined, it's my duty to deliver lecture, it is your right to receive lecture, isn't it? So, in the event of any violation, you can approach a court for appropriate relief, isn't it? Damages or something else. So, rights can be acquired as a fundamental right, contractual right, or statutory rights. What are statutory rights? You have a right to information, isn't it? You have a right to work, isn't it? After 2005, every citizen of this country can have access to public domain and get whatever information that is available, isn't it? Prior to that, it is not in existence. Are you aware of it? So what does it mean? If you want to demand anything from any person, you must have a right. Unless you have a right, you cannot step into the courtroom. You cannot demand anything. Am I clear, friends? What is your IPC? It's a long list of rights, isn't it? Mr. Farooq shall not cause me harm. In Champak, he shall not cause murder. Because, let me remind you, నాకు ఒక రైట్ ఉందంటే మీకు ఒక రైట్ ఉంది టు డిమాండ్ సర్వీసెస్ ఫ్రమ్ మీ, isn't it? Lecture, reading material, everything. So I have a duty to discharge it. So right and liability are two sides of a same coin. Without right there is no liability, without liability there is no right. So the point to be taken is, first, to approach court there must be a right. Okay? Right implies existence of obligation against particular person or entire world, isn't it? Next, if there is a right, what is your IPC? It's a long list of liabilities, isn't it? నువ్వు కొడితే నీకు 1 year శిక్ష, నువ్వు చంపితే capital punishment, నువ్వు ప్రాపర్టీ theft చేస్తే 3 years punishment, isn't it? It's a long list of liabilities. 498A, you shall not cause cruelty to your wife. If you cause it, you are a liability, isn't it? What they are talking about? It's a long list of liabilities. What is your Hindu Marriage Act? Once you get married, wife is entitled for maintenance. Children born, they have a status. And if there is a torture, cruelty, either party is entitled for a divorce. For no valid reason, separately living, entitled for restitution of conjugal rights, isn't it? So, what is your right to work? It says, citizen of this country, rural household, if there is no work, they can apply for MRO for work, MDO for work, isn't it? Every law is recognizing certain rights in favor of individuals, isn't it? What is your Hindu Succession Act? Male Hindu died without writing a will. Legal age prescribed charge, they will get a right, isn't it? So what is the point? Basically, law is recognition of certain rights. Am I clear, friends? Very, very important. మీరు ఎప్పుడు బుక్ చదువుతున్నా ఇది రైట్ అవుతుందా కాదా అనేది ఎన్షూర్ చేసుకోండి. వాట్ ఈస్ యువర్ రెంట్ కంట్రోల్ లెజిస్లేషన్? ఇఫ్ యు ఆర్ ఏ ల్యాండ్ లార్డ్ అండ్ టెనెంట్, రైట్స్ అండ్ డ్యూటీస్ అంటే ప్రిస్క్రైబ్ చేశాడు, అంతేనా కదా? There shall not be willful default on part of the tenant. Landlord shall not cause obstruction for the peaceful enjoyment. What is your Transfer of Property Act? Seller buyer rights and liabilities, leaseholder rights and liabilities, mortgager rights and liabilities, isn't it? Exchange, the same rules of seller and buyer applies. Gift, what are rights and liabilities? Am I clear, friends? You take your even your Contract Act, what it talks about, if there is a contract, how it must be, if there is a violation, what would happen? What is your bailment? One person giving his movable article to a specified person. In the event, what is bailer rights, bailey duties, isn't it? What is your pledge, rights and duties? What is your agency law, rights and duties? Am I clear, friends? If the law is prescribing rights and duties, it is called substantive law. ఇది కూడా టీచ్ చేసి ఉంటారు కదా మీకు. వాట్ ఈజ్ సబ్స్టాంటివ్ లా? దట్ లా విచ్ ప్రిస్క్రైబ్స్ రైట్స్ అండ్ లయబిలిటీస్ is called a substantive law. Your IPC, Hindu Marriage Act, Succession Act, TP Act, they are all substantive laws, friends. Am I clear? This is one important point. So law says once there is a right, in the event of its violation, there will be a recognized remedy. For example, wife and husband are living happily time. All of a sudden some mosquito enter into the mind of spouse. There is a clash between them. The person who is the victim of that clash, example cruelty, they have a remedy to file a divorce, isn't it? Victim of that clash has a right. The remedy is divorce, but not killing that other human being, isn't it? Similarly, somebody killed X. కోర్టుకు పోయి వాళ్ళ లీగల్ ఎయిడ్స్ మాకు చచ్చిపోయిన వాడిని పుట్టి మళ్ళీ తీసుకురమ్మని అడగచ్చా, అడగకూడదా? వై నాట్? చెప్పండి. ఐఎమ్ రిపీటింగ్ ద క్వశ్చన్. I killed X. Whether you can file a case stating that I want that man to be back. నాకు మళ్ళీ వాడినే తీసుకొచ్చి నాకు ఇచ్చేసేయండి అని రెమెడీ అడగచ్చలేదు. ఎందుకంటే ₹1,00,000 అప్పించి ఇవ్వకపోతే ₹1,00,000 తిరిగి ఇవ్వమంటున్నాం. Isn't it? Then why can't you demand? Even specific relief law ఏంటి? మనం ఇక్కడ ఆలోచించుకోవాల్సింది ఏంటంటే you can demand such remedy which is recognized by law, nothing else. That is a basic point. చట్టం గుర్తించిన రెమెడీని మాత్రమే మనం అడగగలం కానీ మనం ఇంకోటి అడగలేం. మీకు ఒక బెస్ట్ ఎగ్జాంపుల్ చెప్తా వినండి. హస్బెండ్ సబ్జెక్టెడ్ వైఫ్ టు క్రుయాలిటీ. ఓకే, వైఫ్ ఈజ్ ఎంటైటిల్డ్ ఫర్ 2 రెమెడీస్, సెక్షన్ 498A and section 39 అనేది హిందూ మ్యారేజ్ యాక్ట్. ఐ మీన్ కరెక్ట్ ఫ్రెండ్స్? డైవర్స్ అప్లై చేయండి. సో వైఫ్ హ్యావింగ్ రిసీవ్డ్ క్రుయాలిటీ షీ ఈజ్ ఎంటైటిల్డ్ టు 2 రెమెడీస్. 1, ఇక్కడేమో 3 years పనిష్మెంట్ ఇప్పించగలరు, ఇంప్రిజన్మెంట్. ఇక్కడేమో డైవర్స్ కూడా తీసుకోగలరు. కానీ వైఫ్ చేతిలో హస్బెండ్ క్రుయాలిటీ గురయ్యాడు అనుకోండి, there is no 498B. He cannot afford this remedy. He can only exercise this remedy. Though there is an injury, unless there is a recognized remedy, you cannot approach court. Am I clear, friends? Very, very important. 304A రోడ్ యాక్సిడెంట్ లో చచ్చిపోతే నాకు మళ్ళీ ఆయన తీసుకోమంటే ఇంపాసిబుల్. వాట్ యూ కెన్ బెస్ట్ డిమాండ్ ఈస్ 2 years imprisonment. That's all. Am I clear, friends? Very, very important. Right remedy. Law recognize certain remedies. So point to be taken is, once you have a right, naturally there will be recognition of remedy. You can demand court only that remedy, nothing else. Law, we generally find 3 things. Number 1, right. In the event of its violation or threatened violation, it will be remedied by way of a remedy, which is also we have discussed. Remedies, there are under civil law and criminal law. Under criminal law, the remedies are like this. That is fine, capital punishment, imprisonment, forfeiture of property, isn't it? These are all and life imprisonment. These are all various remedies recognized under criminal law. Presently, they have recognized even victim compensation scheme also, isn't it? These are certain remedies under criminal law. When it comes to civil law, what are the remedies? Recovery by way of a damages. It can be liquidated or unliquidated, or specific performance, recovery of possession, cancellation, rectification, injunction, declaration. These are all various remedies which you find under civil law. Partition is also one kind of remedy. These are remedies part. So we have seen, and that law basically which talks about remedies, it also contains under substantive law only. For example, you take Hindu marriage. You have rights, you have remedies also. For example, once you become wife and husband, and wife has a certain responsibilities, husband has a certain responsibility. In the event of violation, section 13 recognizes certain remedies. Isn't it? Even IPC, right and remedy, immediately it will follow. Isn't it? 498A definition, they recognize husband shall not cause priority. If he causes, this is the remedy. That is recognized. Wife cannot demand death penalty because it is only recognized 3 years. So please have that in your mind. Am I clear, friends? Next we will discuss the redressal portion. Redressal portion refers to once you have a right and you know what is your remedy. For example, 498A is happened. Remedy wife demand is 3 years and fine she can demand. She cannot directly go to court and say, Judge, Mr. Judge, give me punishment to him. There is a methodology, isn't it? Even under a civil law, one man shall give me 1 lakh rupees. He didn't give. I filed I cannot say that Judge, he didn't give me money, please give you money, or direct him to give money. There is a methodology. What I have to do? In criminal, I have to file a complaint. In civil, I have to file a claim. Isn't it? This is methodology of reporting your grievance. And methodology of reporting your grievance is subject to certain laws. Isn't it? It shall contain material facts, no law, no evidence. It shall contain prayer, it shall contain jurisdiction, it shall contain court views. So, law says, direct గా జడ్జి దగ్గరికి వెళ్ళి ఒక పెద్ద నమస్కారం పెడితే you will not get any remedy. Okay, what you have to do is, you have to put it in writing. Oral is not permitted before a judge. You shall put it in writing. How to put it in writing? Order 6, Order 7, Order 8, Criminal Rules of Practice. They talk about in which page, at which length, on what side, what is it, whether it is oral, whether it is typing, handwritten. Everything is specified, isn't it? So, mere oral mentioning before judge doesn't fetch you any remedy. You shall put it in writing. This is the real work of a lawyer. Either plaint or complaint, converting human grievance into a legally redressable affair. మనిషి యొక్క చట్టపరమైన హక్కుని కాగితం రూపంలో మార్చి కోర్టు ద్వారా రెమెడీ చేయించడమే లాయర్ యొక్క అసలైన డ్యూటీ. Am I clear, friends? That is the crux of your case. That is the crux of your duty, fundamentally. Therefore, ఈ qualities please నేర్చుకోవాలి for lawyer. So once you write a plaint and get it registered, it is almost like climbing to Himalaya. Do you know this? సూట్ నెంబర్ అవుట్ ఎంత టఫ్ తెలుసా తెలీదా మీకు? మొదటి రోజులు వెళ్తుంటే అది అర్థమైంది ఎంత టఫ్. సో వన్స్ యువర్ కంప్లైంట్ ఆర్ ప్లెయింట్ ఈస్ నెంబర్, దెర్ ఈస్ అనదర్ ఫేజ్. వాట్ ఈస్ ఇట్ కాల్డ్? Summons will be sent to opposite fellow, isn't it? After summoning, he will file a written statement. Generally under criminal law, so civil law, if there is a written statement, there will be issues. What is issues? The point of difference between plaintiff and defendant. And issues are framed thereafter evidence. Here evidence law will come. Thereafter arguments followed by a judgment and its execution or appeal. There is one particular law which talks about this process. That's your CPC and CRPC. That's your criminal rules of practice and civil rules of practice. Am I clear, friends? So fundamentally under law, what do you find is there is a recognition of right or liability. In the event of its violation, remedies are also provided under law itself. And mode of reaching from right to remedy, there is a journey called your CPC or CRPC. Am I clear, friends? So even under your JCJ also we read all these subjects.